forgive me if I keep saying Elisha.
Oh, yes.
Elisha Ongoya, who joins us. By the way, he's a lawyer. Is it enough to have that list and say that these are the allegations? Because a lot of people are saying this looks like a diary entry by a police officer. So these are the suspects and this is what I think they've done. Did the EACC speak too soon?
What I don't know is when the executive, the CEO of the EACC took this report to the president, what was the purpose of that report? Looking at these allegations now, on the face of it, one may be tempted to conclude that this was a confidential update from a state agency's CEO to the nation's CEO, that here is where we are on various matters. I do not know whether if you confronted the EACC CEO and sought to know his view as to whether he intended drastic action to be taken on that report at that stage, he would answer it in the affirmative. But going back, from an evidentiary point of view, so far what has been supplied and what you have given your viewers this evening is not evidentiary in itself. It is the allegation that this is the claim we are making against so-and-so and so-and-so. You notice that each of these claims imputes a criminal element. And it is not easy to make a decision to prosecute a criminal case because of certain inbuilt legal requirements. It is a requirement of the law that if you have to undertake a prosecution of a criminal case, you must be ready to discharge a certain standard of proof, which is proof beyond reasonable doubt. It requires that you adduce some fairly credible, solid evidence to be able to secure a conviction against each of the individuals. So far what has been played out to the public is not in itself evidentiary material. It is the allegation, the report that the EACC has received on these individuals. As to whether on those files pieces of evidence, your guess as good as mine.
All right. Now, speaking of this report and just how far the EACC is to prosecution, they have indicated that some of these cases are either under investigation, some are claimed to be under active investigation. I don't know what the difference is. But is 55 days enough, really, to get to the bottom of corruption, as the president has requested?
First, it is puzzling when the president sets the timeline for this action. Because if you look at the EACC, it is an independent commission. It's a constitutional commission by virtue of its very establishment. And if you look at another office that is essential for this process, the office of the Director of Public Prosecution, it is also another constitutional office with their mode of operation set out in the Constitution. These people are not supposed to be subject to directions or control in the discharge of their mandate. And the reason for that
even if they've been constituted together in what Manoy Sipisu this morning referred to as a task force?
This is a loose textured administrative arrangement, but the functions they are discharging are pure constitutional, pure statutory functions. Investigating a crime and prosecuting a crime.
Speaking of crimes, in the allegations that I read out earlier, there are some which people say that I don't see where the crime is here. And I want to specifically point out to Bomet Governor Isaac Ruto. I'm sure we can get that information so that our viewers can see it. He's accused of accumulating wealth, including 40 earth movers worth 400 million, a chopper worth 300 million, and that he bought a palatial home in Ngong worth 33 million, and that he owns numerous petrol stations. I mean, this to me sounds like a financial audit.
It's a financial audit, so that owning the property in and of itself is not a crime. In fact, by the way, in a pure liberal economy, there is no offense like owning property. But for a public office holder, there's what you call a lifestyle audit, where the property ought to be commensurate to one's sources of income, and there is therefore a public duty to be able to explain this accumulation of wealth. And therefore, owning the property in and of itself has no criminal element in it. It's either he refuses to explain the source of that wealth, there could be a crime out of that, or he explains in a manner that is unsatisfactory, in which case there could be a presumption of corrupt dealings that have culminated into that acquisition. But owning property as alleged in and of itself does not disclose any offense on the face of it. And that's why I said one may want to know what was the real purpose of this report. Remember, the report was handed over to the president as a confidential report.
Right.
So that on the face of it, my reading of it predisposes me to presume that the author simply wanted to update the nation's CEO that in the war against corruption, this is what we are doing at various stages.
Okay.
As to whether the CEO understood that to be information being communicated to him at the national level is a different ballgame together that I don't want to venture into speculation.
Now, we want to look at another specific accusation, that of CS of Lands Charity Ngilu, accused of inflating the market price of a piece of land to 110 million, and yet the valuers of her ministry also overvalued it, apparently upon her request. And the question here is, as the EACC, as a CID, where do you even begin? Because the people who can give evidence here might self-implicate.
I mean, that's the challenge of the decision to prosecute historically is never an easy decision. The decision to prosecute, one must evaluate various factors, including availability of evidence that can credibly stand a charge in a court of law. On the face of it, the allegation against Charity Ngilu seems to impute an allegation of abuse of office, where one is trying to unlawfully confer a benefit to another. So on the face of it, there's a criminal allegation. The underlying evidence is a tricky thing that all concerned in this case will have to grapple with. As you rightly pointed out, there are officers in the ministry who apparently overvalued the land, and therefore it would be difficult for them to be, unless of course they are able to demonstrate the pressures of overbearing, but whether one can justifiably argue that those pressures are sufficient for them to commit a crime in the face of the witness protection laws in this country that's supposed to protect whistleblowers and so forth is a very contentious question.
Okay,
and the
so
jury
the question here is, we've seen the allegations. You're saying to me that they don't seem very watertight. So did the EACC bite more than it could chew?
And that's, I go back to where I started from. The EACC is an investigative agency. As an investigator, you receive all kind of reports. You open a file for them. And therefore, if the nation's CEO tells you, give me a full overview of the anti-corruption fight that we have in this country, you may give the entire report. Say, look, these are the various allegations we have received against the various individuals, and this is where we are on each of these files. Whether the EACC ever intended, or whoever it is that gave the president the report, ever intended that at that juncture the president declares that certain specific steps be taken on those files is a different argument altogether. I personally would at least substantial doubt that in light of the allegations that I'm seeing, that was the primary intention of whoever furnished the president with that report.
Now, I'm going to ask you a question which will require you to put on your hat as the Dean of Law. Is it possible that the EACC could be withholding this crucial evidence that could see these persons prosecuted, that they just don't want to release it to the public just yet?
It is one of the possibilities that as an investigator you have information and you are supposed to verify various elements of this information before you make it public, because part of it can be a bit damning on people's reputations. And yet we all know that if you are an investigative and prosecutorial agency, your role is what you call quasi-judicial. You have a duty to be fair to everybody as you make a decision, because each of these decisions has practical consequences on people. And one will therefore assume that in some of those instances, perhaps the EACC has pieces of evidence. But it would be extremely reckless of us to conclude that indeed the EACC has any evidence, because the EACC has not declared up to now to the public that we have this quality or this quantity of evidence against this individual. The burden is on them. Remember, each of the individuals named has a presumption constitutionally prescribed acting in their favor. The presumption of innocence.
Right.
The burden is squarely on the part of EACC, if and when it has evidence, to be able to disclose that evidence and to be able to therefore utilize that evidence for purposes of any other stages moving forward. But looking at the allegations as they stand, well, the jury is still out there.
The jury is still out there. I'm being told that we're out of time, but I would like to ask you one question, which you would be doing me a huge favor if you answered rather quickly. We've said that there are 13 governors on this list, and there are 6 sitting members of parliament, and we know that the constitution does not have any provision for them to step aside, as it were. Do you think the EACC, the CID, together with the officers of the DPP's office, will be able to come up with evidence that is solid enough to see them put away for 12 months or more, which is what is required for these persons to leave office?
If you look at the Anti-Corruption and Economic Crimes Act as read with the Ethics and Anti-Corruption, the Ethics and Anti-Corruption Commission Act, you'll notice that these are public officers, essentially. And strictly speaking, once charged in court, they are supposed to stand suspended once charged in court. If and once charged in court. As we speak now, no one has made a decision to charge, and that's why this task force has, I suppose, been set up to be able to see who is going to be set up. But I think, strictly speaking, it's a good test. Part of the questions Kenyans have been crying about is, so when shall Chapter 6 of the Constitution acquire any practical meaning?
Right.
And I think, assuming that the commission has solid evidence, and that, I say, the jury is still out there, then it's a good experiment that we have invested in to be able to now give a practical opportunity for Chapter 6 of the Constitution to be able to assume some measure of life.
Elisha Ngoya, thank you very much for making time. Dean of Law and also a lawyer, and obviously a brilliant mind when it comes to analyzing this sticky situation.